So if you're faced with this kind of situation, someone who's being asked to join a board, is it all upside? Is it all something you, oh, sure, I should do that, it's something I should definitely want to do, or are there downsides?
Okay, and what I would say is it's not a free ride. You got to take it seriously. It's a responsibility, and if you're just going to get your name out there, I wouldn't do that. If you're really interested in the business and in making it succeed and going to take the role very seriously and participate like you would if you owned the business and were responsible for it, then I think you could protect yourself in this situation. There is risk, and if you read the papers, you see directors get sued. In this situation, in this startup situation, there seems to be less risk. You're not aware of any conflict in the company. You're not aware of necessarily differing interests of shareholders at this point, but it's something to be cautious about. So what you want to make sure of is that you are protected to the maximum extent you can under law, which means that the charter documents for the entity should have the appropriate provisions in there, appropriate exculpation provisions, appropriate indemnification provisions. I would want to see you'd want to see those documents, have someone look at them and say, this looks good. Number two, I'd like to see what the investor directors have put in place, and if they put in place indemnification agreements, I'd surely want you to be at least in the same position as they are. And third, I would ask about D&O insurance. And for startups, usually in this kind of business, you can get pretty inexpensive D&O insurance. If there are institutional investors involved, I think they very well may have required that, and you should ask about that. And if it's not in place, it's something you can ask them about. And there's a risk, it would be better if it has it. Let's put it that way. And I think before they go into a second round of financing, I think that should be something that you say as a board member should be put in place.
So let me just make ssure I understand. So what are the kinds of liabilities that a director in this kind of situation might be exposed to? What are the fears that they should have in the fore part of their brain when they think about this? Okay. Who's going to sue?
Yeah, a few things. One, I think the biggest risk is actually claims among shareholders in a situation where presumably your student was the founder, got common stock, and now you have the investors coming in and getting presumably preferred stock. And there may be a conflict of interest at some point between them, and maybe some other people have stock as well. So behaving fairly, the people who are controlling the business now, behaving fairly as to the other stockholders, and you as a board member ultimately deciding some of these things, making sure you take that responsibility seriously and are not just following what sounds okay, but think about it and making sure where there are conflicts of interest, you're understanding what they are and dealing with it. That's probably the biggest thing that comes up in a small company.
Now, could I ask, if there's the distinction between a duty of care obligation and a duty of loyalty obligation.
Right.
Would that fall under a duty of care obligation or a duty of loyalty obligation, or is that not clear?
I think it depends on the facts of the situation. It's clearly a duty of care, and I think whether you're looking at the best interest of the company and not one of the shareholders. So you won't be able to think just about your student there. You have to think about the other shareholders, and that's a really important responsibility. You have to act what's in the best interest of the company. Duty of loyalty could come up in a number of different ways, but one of them could be is what if you hear about a great idea that you'd say, wow, this is perfect for the company, but you know what? I like to do this on my own. I'm going to go someplace else. Now you have a responsibility to the company. And one of the things you should look out for, if that's at all on your mind, is whether there's appropriate provisions in the charter, if it's a Delaware corporation, where you don't have that responsibility, where you may be able to take opportunities and specify what this business is focused on and what it's not focused on. So there's things to think about, but if you're excited about this, you understand the responsibility, you understand what it means, and you're going to take it seriously, I think this is as good an experience as you can get.
So tell me a little bit more about what an exculpation clause is.
So an exculpation clause is a provision that's allowed under most state statutes, I think practically all of them now, which says basically you will not have liability if you act according to your duty of care, essentially. And you won't be open for liability. That doesn't protect you, in most states, probably all states, from breaching the duty of loyalty. So no matter what, you have to be looking out for the best interests of the company and shareholders, not your interest and not something that benefits you. And if you're doing that, a strong exculpation clause, which you can examine in the documents, should be very helpful.
So that sounds like a bare minimum.
Absolutely.
Why would you ever join a company that doesn't have an exculpation
And it's
clause?
pretty standard. So if it would be one indication to you, if they don't have it, that they're not doing it. They're not acting as they should be from a legal
And
perspective.
then the thing you mentioned next was an indemnification provision, but you also mentioned indemnification agreements. Is that belts and suspenders? Do you need both, or do they serve different functions?
Typically, indemnification clauses will say in bylaws or a certificate of incorporation, they'll indemnify to the maximum extent permitted by law, but it doesn't get into any details. The purpose of an agreement would get into details on certain things that could protect you even more in terms of both on the expense side and when it comes up and what the responsibilities are, and just clarify the responsibility so the issues that are really important to you are covered.
I hear that most people focus on the issue of making sure the attorney's fees get paid, at least in advance, unless it turns out you're not entitled to them. But that would be one thing.
One key thing that frankly should be an indemnification clause in the charter documents, but you'd want to make clear about that. That's in these if there is a problem, if a problem comes up, that's oftentimes, unless you're behaving badly, it's oftentimes the biggest expense, and that's a big expense in these things. So you do want to make sure that the company is responsible. If you get into that situation, unfortunately, in a startup like this, there may not be enough money to pay for that. So that's the reason, if they can get insurance at a reasonable cost, it'd be worth doing it.
Okay. And so you think that it would not be unreasonable for Professor Wu here to insist that they get insurance if they're going to bring him on, if they don't have it already?
Exactly. Unless there's some good reason why not, and then I would surely insist if you came on that you get it before the next round of financing.
Mm-hmm. And certainly before they go public.
And certainly before they go public. Absolutely.
Great. Thank you very much.
Okay.